Happy Inauguration Day, everybody. We have some good news. Welcome to my channel, y'all. I hope you're having a great day. And a great day it is. Of course, it's Monday. It's pretty chilly out there, but we do have the inauguration of Donald J. Trump. He's returning to the White House. And as I don't know if it's a gift to Canada or what, but he has decided to pull back on his 25% tariff threat. Now, we kind of knew that this was probably going to happen because that's the way he negotiates, but we'll see how this goes in the future. Another thing is that it is college football playoff, the championship game today. Probably not going to get a chance to watch it live, but I am recording it, and all I can say is, hey, go Notre Dame. That's the team that I am rooting for. Now, the other really good piece of news, actually, this occurred during the weekend on the 18th. So on Saturday, which is interesting. So on Saturday, the federal court ruled that they will have an expedited hearing on the case that is challenging the prorogation of Parliament. So that is really good news. To start this off, and that's the focus of this video. So I'm going to start off with reviewing a little bit of the court document, and then we'll talk about it. What I found really interesting about this court document is the date. The date is the 18th of January. So why I find that interesting is it's a Saturday, which means that somebody at least was working on a Saturday. I was under the impression that this hearing was supposed to be on the 16th, so 2 days prior to that. That's the information I had. That would have been a Thursday, and maybe it happened on that day. Maybe this was just when the ruling was published, which is possible. I'm not sure about their exact procedures, but it means that it's important enough to the court that at least somebody was working on the weekend and possibly even hearing the court challenge. So that's very, very interesting. Of course, we do have the lawyers, the applicants, and then the respondents. So in a civil matter, the applicant would have been the plaintiff, respondent would have been the defendant or what have you. But what we have here is an administrative court. So it's an application. It's not really a lawsuit. So the motion that was put forth was that this application needed an expedited date or an expedited procedure. So in Canadian courts work very slow, probably slower than most courts do. I know that courts in England and courts in the United States do have rules to make them go faster than Canadian courts. But in this case, it was ruled that it was of sufficient importance to have this matter heard before the courts at an expedited rate. So that is very, very interesting. Now, of course, the Crown, the Attorney General for Canada, they opposed this. So what they did was they gave some really lame excuse that it really wasn't all that important. What I found very interesting is that the applicants, their main argument was the 25% tariff that was being imposed or threatened to be imposed by the United States as an argument for it being urgent, and which is kind of funny because now Donald Trump has said that he will investigate whether or not that 25% tariff is justified. So he's not imposing it on his first day like he threatened to, but it's still looming. So that's of importance as well. Now, I would have also argued that it is important because if it wasn't expedited, then basically it wouldn't get heard in time and Parliament would be back in session. And then what would be the point? Now, they could have still heard this case after Parliament came back because it is of significance to our whole system, our parliamentary system. So they could have ruled that even though it's a moot point, we're still going to hear it because it could make precedence of whether or not prorogation can be called or when it can be called in the future. Now, in part of their rationale for opposing this expedited application, basically schedule, the Crown, the Attorney General for Canada, argued that there's still a government, they're still negotiating with Trump, and if need be, they could recall government at any time. So essentially, the executive was still functioning. The court obviously decided that that was a pretty lame argument. They ignored it, and they set this new schedule. So right now, let's go to that part of the order and see what the new schedule is going to be like. So this, of course, is the crux of the matter before the court on the 18th. This is going to be the new compressed schedule to hear whether or not prorogation was justified and whether it should or should not be nullified. So this court orders that 1. The motion is granted. The timeline set forth in the rules for the hearing of applications in this court shall not apply to this application. Instead, the schedule for the hearing of this application shall be as follows. A. The applicants shall serve supporting affidavits and documentary evidence and file proof of service by January 22nd, 2025. So that's 2 days from the time that I'm recording this. I'm recording this obviously on Monday, Inauguration Day, and they have to file their affidavits and documentary evidence by Wednesday. B, the respondent shall serve supporting affidavits and documentary evidence and file proof of service by 10 a.m. on January 27th, 2025. So that's next Monday. So 7 days from the time I'm recording this, and that is the day that Parliament was supposed to be back in session before Trudeau pulled this prorogation scam. C, the party shall complete any cross-examination by January 29th, 2025. So next Wednesday, they're going to have their cross-examinations done. I'm not exactly sure what that means because the hearing date is set later on, but that probably means that they can, cross-examine the lawyers, have some sort of a pre-conference or something like that. I'm not exactly sure what is going to go on there. D, the applicant shall serve and file an applicant's record by February 3rd, 2025. So by the following Monday, they have this other date, so they're going to file their record. Then by that Friday of that following week, paragraph E says that the respondent shall serve and file a respondent's record by noon of February 7th, 2025. So as you can see, things are kind of clicking along here. We're getting a few weeks into this now. So that's, coming up on about, almost 2.5 or weeks from now, maybe 3 weeks. F, any interveners, and this is getting interesting here. Any interveners who may be granted leave to intervene shall serve and file their submissions by February 10th, 2025. So that's obviously the following Monday. What I find very interesting is G here. And primarily because of the timeline, the applicants and respondents shall provide any reply that they may wish to make to submissions made by any interveners who are granted leave to intervene orally at the hearing. And they have until, and they can do so in 5 pages, up to 5 pages or less, and they can submit that by February the 18th. So that's 4 days after the last hearing day. So obviously the judge is not going to make any decisions on the last hearing day, which is pretty typical. Actually, they normally take time to really consume the information and break it down and analyze it. H, the hearing shall take place in Ottawa on February 13th and 14th, 2025. So that's a Thursday and a Friday. So as you can see, it's kind of getting pushed down the road here. By the 18th, that's almost a month from now, give or take a couple of days. So, and that the judge won't decide on the 18th after the interveners have submitted any written arguments. He will take time to review all the arguments and all of the oral applications during the actual hearing itself. Even if he's made up his mind right now, he can't let on to that. So, and he may change his mind even if he has made up his mind. So essentially what's going to happen is he's going to take at least a week, I would say, to review all of the evidence submitted to him and then prepare his written ruling. And that written ruling will be obviously typed up by his staff, and then he'll sign it. At best case scenario, I would say that we're looking at the 24th of February for a ruling, possibly a couple of days after that. But I expect it the 24th. If he rules on the 24th, then by the 25th, Parliament should be in session. Maybe they will, maybe they won't. I know that in the UK case, of course, the United Kingdom being a much smaller country physically, then you could, wrangle your MPs and get them back in Parliament. Well, once the decision was made by the UK Supreme Court, Parliament was in session the next day. I'm not sure that would be possible in Canada because we're pretty slow here, or at least government is. But let's say that it is the decision does come down on the 24th. Maybe by the end of the week there, Parliament will be in session again. Now, Parliament doesn't necessarily have to be in session for the committees to be in session. And this is where it gets really interesting, because once prorogation is declared to be, unjust and that it shouldn't have happened, and now that it's overruled by the federal court, providing, of course, it goes our way or the way that most Canadians want it to go, and found to be, unreasonable and therefore nullified, then the committees can start sitting again. And the Conservatives, they control the Public Accounts Committee. And what they were planning on doing is submitting a report to Parliament. And all reports from Parliament, especially from committees such as the Public Accounts Committee, which deals with finance, have to be voted on by the House. And in that report, they're going to specify somehow, I'm not sure what the wording will actually be, but they're going to specify in that report that the House has lost confidence in the government, which will trigger a non-confidence vote and then potentially bring down the government. Now, once they submit that report, how soon will it be voted on? I'm not sure. It could be another week down the road. So as you can see, we're getting really close to the date that the Liberals were going to, choose their next leader, especially since in committee, the Liberals have a nasty habit of filibustering and calling points of order on everything, even when they're not points of order, just stalling the process. So you can expect that for sure. I think they do have a plan to push this through. I'm not sure what that plan is. Once I hear that the committee is scheduled, I do plan on dedicating some time actually watching that committee, possibly even live, to see what's happening, although that will probably be quite boring. So I'll, maybe watch it live and broadcast it live and then, edit it down. But I think that that's really, this is positive news. Even though the timeline is getting stretched out there, The reason why this is really important is it creates a Canadian precedence over and above the British precedence, and that will affect future governments. So no matter which party is in power, if they want to prorogue Parliament, they're going to have a legit reason in the future, provided this goes our way. So a government facing a non-confidence vote won't just be able to prorogue Parliament to save their government. So I think that is really important, and it's very, very important for this decision to come down, and it's important for it to come down in our favor, or in the favor of most Canadians. But that's just my opinion. I'd love to know what you think. Put your comments down below. And while you're at it, please like this video, share with your friends and on social media. And if you haven't already, please subscribe to my channel and hit that bell notification so you never miss another video. Also, please join me on Thursday evenings at 6 p.m. Pacific time on YouTube and on Rumble for my live stream, where you're invited to join in on the conversation. Finally, if you reside on Vancouver Island and you want to get your firearms license, I do teach the required courses. So if you want your firearms license, there are links in the description of this video to my website where you can sign up to take a course from me. Thanks for watching, and I'll see you in the next video.